Assalamualaikum to our beautiful lecturer, Dr. Nurishal.
Today, our group would like to present about our group assignment.
Hey, hi. My name is Tuan Nurishalika binti Tuan Sri.
Hi, my name is Nur Anifatia binti Muhammad Sofi.
Hi, my name is Qurratu Aini binti Abdul Sattar.
MOA and AOA changed to Constitution in CA 16. MOA and AOA is two documents that needed before incorporate a company.
Okay, what is Constitution? Constitution is about all the basic information about the company and also other matter about the company internal management. Under Section 31 and Section 38, only company limited by guarantee is required to do Constitution. And for other company, the Constitution is optional for them. So they can choose to do the Constitution or not. For a company limited by share, they can choose whether to do Constitution or not. For a company limited by guarantee that want to do Constitution, the detail that they need in the Constitution is company objective, the right, the capacity, the privilege and power of the company, including the number of members.
What is par value regime? Par value regime is the set of minimum amount of shares of similar class that can be sold during the initial offering.
Means that the issuing company promises not to issue more shares below a defined value. This specific value is called as par value, so that investor can be assured that no one else will receive a more favorable issue price.
So the par value regime in the Companies Act 1965 told that the share should be in a par value regimes. But in Companies Act 2016 told that the share can not have a no par regime. So we go to the effect of no par regime. First, with the abolition of par value, the share premium is no longer exists.
This concept tied to par value under Companies Act 1965 will be abolished, which is the share premium account that representing the total premium over par value paid of share. The capital redemption reserve, where a reserve into which amount are transferred following the redemption or purchase of company's own shares, and also the authorized share capital, which represent the maximum number of shares a company can issue multiple by its par value.
So that the shareholder of the listed company will accept to the windfall as a companies would have a capitalist or rather clear up their share premium account by issuing bonus of share. Secondly, by retiring the par value regimes, the companies will have a greater flexibilities in a structure of their share capital.
Previously, it was an ironclad rule that shares could not be issued at anything less than their par value, and they could not be issued at a discount. However, the director will still have a fiduciary duty to set the price of share in a good faith.
And the thirdly is the theoretical liability that arise from the par value system.
The par value of stock constitutes a binding, two-way contract between company and the shareholder. If the shareholder pay less than the par value of the share of stock and the issuing company later become unable to meet its financial obligation, its creditor can require the shareholder pay the difference between purchase price and the par value as means of fulfilling the company's unpaid debt. On the other hand, if the market price of the stock fall below the par value, the company may liable to shareholders for the difference.
What is annual general meeting? In relation to a public company, means annual general meeting means a meeting of the company required to be held by Section 340 in the Companies Act 2016. In the Section 340 subsection 1, stated that every public company shall hold an annual general meeting in every calendar year. Why do we held annual general meeting? Annual general meeting is to be held because it is to manage the following business, which are the laying of audited financial statements of the company and the reports of the directors and auditors, the election of directors in place of those retiring, the appointment of the fixing the fees of the fee of directors, and any other resolution. The meeting is also to manage other business of which notice is given in accordance with the Act of the Constitution. Annual general meeting shall be held within 6 months of the company financial year end and not more than 15 months after the last proceeding annual general meeting. In the Companies Act 1965, annual general meeting is required by the company, whether it is public or private, to hold an annual general meeting every calendar year and not more than 50 months after the holding of the last proceeding annual general meeting. The meeting was recognized to be burdensome and costly for private companies. This is especially to those that are closely held by a few directors or members, or run by a family business. Since private companies usually runs by family business, so it may be costly. In the current Companies Act, which is Companies Act 2016, annual general meeting are no longer mandatory and removed for private companies. Despite audited financial statement is no longer put before the annual general meetings, it must be circulated to members within 6 months of financial year and lodged with the SSM within 30 days of circulation to members. The abolition of annual general meeting for the private companies will mean that the election of directors and auditors and retirement of directors will be held separately. For the tabling of audit financial statement and lodgement of annual returns also will be dealt separately and not be tied to the holding of an AGM for private companies. The members of the board of directors will still have a right to receive audited financial statements, although they would not have the benefit of the forum of a general meeting to discuss and question the directors on such statements. The conclusion is, for the private companies, they are no longer mandatory to hold annual general meetings for lessen their burdens, since annual general meetings are costly to them.
So, a company may be incorporated as a private company with a single director who must be, first, resident in Malaysia under Section 196. Second, the sole director may able to be a sole member. She also able to declare under oath that she are not a bankrupt person. The third one is not been convicted for any of the offence prescribed under the new Act. Linda Venus have to follow all the steps under the regulation under Companies Act 2016 to register her company with a private limited company with a sole director.
The qualification to be a director that Linda need to be is she is not an executive director to the listed company or any related corporation. Linda also has not been within the last 2 years and not an officer of a listed corporation. Next, she also not a major shareholder of the listed corporation. Linda cannot be acting as a nominee or representative of any executive director or major shareholder of a listed corporation.
The sole director or the last remaining director of the company cannot resign or vacate his office under Section 196 until the director has called a meeting of members to receive the notice of the resignation and to appoint one or more new directors under Section 209. Moreover, the secretary must call a meeting of a next of kin, other personal representative, or a meeting of a member if Linda Venus dies. She dies and she is not appointed within 6 months of his death. So the registrar may direct the company to be struck off. For her company, the company execute a document by the sole director, signing the document in the presence of a witnesses who attend the signature. The decision of a company with a sole member may be made by one written solution, or where any decision of the company is made which may be taken at the meeting of a members or has effect as if it had been agreed at a meeting of members. So, Linda is the only director in the company. She might be a person that authorized to act on behalf of the business. She may be unable to leave her business or extend the period when she leaves. The effect of the decision making of a sole director. First is decision of a company with a sole member may be made by a writing of resolution. Second is a decision made from the single director might be less of ideas. And the third one is the decision making of the director will not have a person that can be a judgment toward her decision since she is the single member. And lastly, Linda will gain less information needed to make a decision.
A private limited company shall name its company with a name that ends with the word Sdn Bhd or a short form SDN BHD based on the section 25 subsection 1 paragraph A. The client, Linda, shall apply to the registrar to confirm the availability of the proposed name. Linda Venus wished to change her company from a sole proprietorship to a private limited company and change her company's name. What is sole proprietorship? Sole proprietorship is a business that owned by a sole owner. The owner will be legally responsible for all aspects of the business. The owner is also responsible for the liabilities of the business, include all personal assets of the owner, including any asset jointly owned by another person. In the Companies Act 2016, Section 40 specifies that an unlimited company may convert to a limited company by passing a special resolution and shall lodge notice of conversion from an unlimited company to a limited company with the registrar. Upon the lodgement of the notice for conversion, the registrar shall make such endorsement in or alterations to the register to record the conversion from a sole trader to a private company and issue to a company a notice of conversion. The registrar then needs to cancel the previous notice of registration or certificate of incorporation of the company. Furthermore, the conversion will not give any effect to the identity of the company or any rights or obligation of the company. If the registrar is satisfied, the registrar shall enter the new name of the company on the register in place of the former name and issue a notice of registration of the new name. A change of name shall take effect from the date of the notice of registration of the new name has been issued. In the meantime, the new company's name must be available to use according to the section 26 subsection 1. If it is not undesirable or unacceptable, it will be determined by the registrar that the name is undesirable or unacceptable if it contains words of an obscene nature and contrary to public policy. The new name must be available if it not identical to an existing company, corporation or business, or the name is being reserved under the Act. The name also must not a name of a kind that the minister has directed the registrar not to accept for registration or prohibited to use. The prohibited names such as the name that connect with the royal family, state or federal government or any agencies, municipality or other authority. Next procedure is the change of company's name. Based on the section 28 in the Companies Act 2016, the company may resolve that its name be changed by special resolution. The company's name shall lodge the company shall lodge application for change of name with the registrar within 30 days from the date of the special resolution was passed. If the registrar is satisfied, the registrar shall enter the new name of the company of the register. The next step is that the company need to submit application for availability of names and reservation to the registrar. The registrar shall the power to determine whether the name is undesirable, unacceptable or identical. If the registrar is satisfied with the name, they shall confirm the availability of the proposed name and reserve the name for a period of 30 days from the date of lodgement of the application of such longer period as the registrar may allow. The last step, after the registrar have confirmed and approved the new name of the company shall disclose the former name of the company for a period of not less than 12 months from the date of the change. The former name should be appearing beneath its present name.
Board meeting is a formal meeting for both public company and also private company. They will meet up and discuss on strategic matter and other information. During the meeting, there should be a minutes recorded. The person who is in charge to record a minute is a company secretary. As a company secretary, they should ensure that the minute record is well taken and not result in any difficulty in the future. As the CEO of the company, Alex Chan is responsible for every company decision. So, the responsibility of CEO is different for each company because it depends on the company's structure and also the size of company. For smaller size company, the role of CEO is more hands-on in decision making of the lower level business. For larger company, the CEO is usually deal with high level strategy and decision. As the director or CEO of company, they should declare their interest in proposed transaction and decision to ensure they did not overpass their duty. The declaration of interest shall get authorization from other directors, and the declaration shall be made in advance before entering the agreement. If the director fails to declare their interest, then he decides to declare the interest, general notice should be prepared. Any addition to the minutes of meeting cannot be simply added. Instead,
General notice
should be prepared. After the general notice is prepared, Natasha should call up meeting and the general notice should be brought up and read during the meeting.
To be a director under Section 196, a company shall have at least a minimum number of directors. For a private company, must have at least 1 director, and for the public company, must have at least 2 directors. It also must be 18 years old and above. And also, the director have to be a resident in Malaysia. Azan can be disqualified from being a director under Section 198. First, a person is an undischarged bankrupt. Second, has been convicted of an offence relating to the promotion, formation or management of corporation. Third, has been convicted of an offence of fraud and honesty. Fraud has been disqualified of the court under Section 199. Lastly has been convicted of an offence under Section 123, 213, 217, 218, 228, and lastly is 539. Section 201. The consent to be a director shall not be appointed as a director of a company unless he has consent in writing to be a director and make a declaration using form. Azra's name as a director is an application as incorporation of a company shall hold office as a director from the date incorporation until the person ceases to hold office as a director in accordance with the Act. All subsequent director of a company may be appointed by ordinary resolution. The board may at any time appoint director in addition to existing director, and the director to appoint shall hold office where in the case of public company until the next general meeting, while in the case of private company in accordance with the term of appointment. Section 203. To be voted individually. At general meeting of a public company, the motion for the appointment of two or more persons as director by a single resolution shall not be made unless a resolution that the motion shall be so made has first been agreed to by the meeting without any vote being given against it. The provision for the automatic reappointment of retiring director shall not apply where a resolution passed in accordance with a motion. The act of director or manager or secretary shall be valid notwithstanding any defect that is discovered after his appointment or in his qualification. The requirement to be a secretary under section 241. Natasha have to register with the registrar before she can act as a secretary. Next is a satisfaction of the qualification and requirement under the Act. The qualification to act as a secretary under section 235. First is a natural person. Second is must be 18 years old and above. The third one is a citizen or a permanent resident in Malaysia. Those are the roles and duties of a secretary, which is Natasha should familiarize herself with a provision of a memorandum and article of association of the company. Second, she should be well versed with securities, law and regulations. She also needs to ensure that any document authentic by her represent the exact copies found in the statutory books, register and secretary file. Natasha has to take and record the minutes of a corporate meetings. She also should follow the company secretary's code of ethics developed by the company's commission. Natasha can also advise the chairman about the procedure that she do to record the right thing in the minutes of meetings. The company secretaries have a fiduciary role to always act in the best interest of the company in good faith and to avoid or disclose any potential conflict of interest that could arise. Natasha can give her extensive knowledge of legal and compliance framework together with the internal governance of company. She also can communicate with directors and shareholders, providing them with key information about the company to formulate strategy or to complement the decision-making process.
Disclosure of interest in contracts, proposed contracts, property and office. Under Section 221, Subsection 1, subject to this section, every director of a company who is in any way, whether directly or indirectly, interested in a contract or proposed contract with the company shall, as soon as practicable after the relevant facts that have to the director's knowledge, declare the nature of his interest at a meeting of the board directors. Next is under section 221, subsection 2, the requirement of subsection 1 shall not apply in the case where the interest of the director be a member or creditor of a corporation interested in a construct or proposed contract with the first mentioned company. Under Section 221, subsection 3, a director of a company shall not deem to be interested or to have been at any time interested in any contract or proposed contract by reason only in a case where the contract or proposed contract relates to any loan to the company that the director has guaranteed or joined in guaranteeing the repayment of the loan or any part of the loan. Moreover, the notice referred to in subsection 4 shall be of no effect unless the notice is given at the meeting of the directors or the director takes reasonable steps to ensure that the notice is brought up and read at the next meeting of the directors after it is given. Under subsection 6, every director of a company who holds any office or possesses any property where duties or interests may be created in conflict with the duties or interests as director shall declare in fact and the nature, character and extent of the conflict at a meeting at the directors of the company. Next is subsection 7. The declaration shall be made at the first meeting of the direction held as paragraph A after he becomes a director, or paragraph B if already a director after he commences to hold the office or to possess the property. As the case requires, under subsection 8, the secretary of the company shall record every declaration made under this section in the minutes of the meeting at which the declaration was made.
Under Section 197, subsection 1, a person who is connected with the director. It shows that person which is Hashim has relation and connected with Hashim, which is the director of Highland Development Berhad (HDD), because he is the member of the director family. Under Section 197, subsection 2, paragraph B, a family member of the director includes spouse, children, parents, and spouse of the director, sister, brother, and children. Since Hashim is the spouse of Hashim's sister, he can be a member of the director family. More or less, he actually has influenced Hashim during the decision making. In this situation, the shareholder has decided to remove Hashim in the next annual general meeting. Under Section 206 in the Company Act 2016, public company has right to remove their director before expiration via the ordinary resolution. Under Section 206, subsection 1, paragraph B, the removal of director will not take place until the new director is appointed. The board is responsible to appoint any capable and appropriate person to be the director to fill the vacancy.
The shareholder will give the special notice to the director to inform him that he is removed.
During the receiving of special notice, the director has right to prepare a written representation or oral representation to the company. Under Section 221, subsection 12, if a director of company is involved in any contract that is possibility influence in the decision making, shall face first, in prison for term not exceeding 5 years. Number 2, fine not exceeding 3 million ringgit. And number 3, both of the penalty above. What are the defenses that available for the director? First, the director can request the member to notify and receive the representation that he prepared. Number 2, the director can request that his representation is read out during the meeting. Number 3, the director also have right to attend the meeting of shareholder that wanted to remove him. the company may suffer due to the process of appointing the new director and also possibility to face legal action taken by Hashim. This is because Hashim protesting his innocence and threatened to take legal action if the company decide to remove him as a director.
Okay, that's all from us.
I hope that our presentation is clear.
And comply with the Company Act 2016.
Thank you. Bye.